In the 2018 case of Masson versus the state of Queensland, the people are represented by two separate yet equally important groups: the paramedics who tried to save a life, and the estate of the late Jennifer Leanne Masson, who sued the state for negligence. These are their stories. On the 21st of July 2002, the Queensland Ambulance Service was called to Miss Masson. She was suffering a severe asthma attack and was primarily treated by intensive care paramedic Mr. Peters. Upon arrival, she was observed to be moderately tachycardic and hypertensive. Paramedics treated her for the following 21 minutes, administering aliquots of salbutamol to minor effect. With arrest imminent and her situation deteriorating, Mr. Peters changed his pharmacological treatment to adrenaline. Miss Masson was transported to hospital and subsequently diagnosed with a severe and ultimately fatal hypoxic brain injury as a result of her asthma attack. It is important to assess the cases and the arguments put forward during the numerous trials of this case before the courts. Although the ruling of the cases have changed, the fundamental points underpinning the alleged negligence have not. Let us explain why there was no negligence nor breaches in the duty of care related to the aforementioned aspects that ultimately led to Miss Masson's injury. How and what laws were the judges to draw upon in order to establish a ruling of negligence? It is accepted in healthcare that clinicians must exercise a reasonable standard of care during treatment to omit any acts which could cause foreseeable harm to patients. Today, a person is legally obligated to maintain a standard of care in order to reduce their risk of harm that under given circumstances a person qualified at the same level as them would have maintained. However, prior to 2003 and the Civil Liability Act, the Boland principle was used as a precedent to determine negligence. This was established in 1957 and set the doctrine for ongoing negligence suits. It determined that acts were not negligent if they were in accordance with what was considered reasonable by a body of medical practitioners of the time. In order to establish if negligence has occurred after considering the Boland principle within common law of Australia, the plaintiff needs to establish the burden of proof to justify negligence. In order to establish this proof, the plaintiff needs a standard of proof, this being the balance of probabilities as mentioned within the Evidence Act of 1995, which in this case would suggest that the early administration of adrenaline would have been more likely to reduce the severity of the injury Ms. Masson sustained. Let us now see how the judge ruled on the cases, keeping in mind what Ms. Masson's estate has to prove and who may testify in support of the plaintiff and the defendant. The ruling of the 2018 Masson versus the State of Queensland case found no breach of duty of care, and thus the claim from the plaintiff was dismissed. The judge relied heavily upon expert testimony, both in support and against the use of either pharmacological agents, thus not fulfilling the criteria to be ruled negligent. The judge also established on the balance of probabilities that it was not too late at the time of initial treatment for Ms. Masson's injury to be avoided by administering adrenaline. However, in his summating remarks, the judge noted that this foreseeability was aided by information that the ambulance officers did not have at the time. The judge recognized the possibility of a different outcome, however rightfully considered Mr. Peters' knowledge at the time. This was also critically underpinned by the judge's assessment of the clinical practice guidelines as a guide for practice and not a set of direct instructions. Therefore, from our assessment, the judge's decision in ruling with the defendant against the claim of a breach in the duty of care was correct. However, as with all things in the field of ethics and law, there is an element of fluidity involved. This came in the form of an appeal to the High Courts of Queensland regarding the initial ruling, resulting in the Queensland Ambulance Service being vicariously liable for the actions of Mr. Peters. The appeal judge believed that the flowchart required the officer to consider solely adrenaline and not salbutamol. This assumption resides around the contentious nature of the word consider. How can a paramedic be found to be breaching a duty of care when the guideline states to consider the administration of a drug? Such is the nature of a paramedic's role to make a clinical decision based on the patient's presentation. As seen in the 2006 case between Worley and New South Wales Ambulance, improper administration of adrenaline without reasonable care and skill can cause significant harm, breaching the duty of care. Based on the judge's inference of the legal presentation of the CPM, along with emergency practitioners' medical opinions, it was concluded that Mr. Peters was negligent, and on the balance of probabilities, adrenaline would have avoided Miss Masson's hypoxic brain damage. But is a reasonable person in the role of an emergency practitioner versus that of a paramedic comparable to make this judgment? To answer, no, as emergency practitioners have a greater expected knowledge than a paramedic. This consideration recognizes the conspicuous error in the judge's decision in addition to his misinterpretation of the CPM's implications. This is further supported by the overturn of the High Court's appeal in 2020. The definition of the word consider was scrutinized by the appeal judge, when the CPM explicitly states that this term implies that the ambulance officer has to make a judgment based on potential benefits and adverse effects, and does not imply that the following treatments are automatically appropriate or sanctioned. The High Court judge commented upon the misinterpretation by the appeal judge and found him to have wrongly construed the CPM and the implications of the word consider. This, along with the fact the CPM is implicated as a guide and not determinative protocol, would reason that Mr. Peters was right in using his clinical judgment. As well as critiquing the law of the case, we should take a moment to delve into the chasm of ethics in the practice of law. So,
tell me whatever don't make things so complicated.
was Mr. Peters acting unethically? Was he acting outside the ethical values outlined in the Public Sector Ethics Act 1994? Did his ego drive his actions and his choice of a drug administration? It can be argued that he used his clinical knowledge to evaluate what he believed was the most beneficial treatment to Miss Masson. He used his clinical and moral reasoning and non-maleficence to follow the treatment plan that would do the least harm. Not only did his decisions prioritize the health of Miss Masson, Mr. Peters' actions were within his legal scope of practice and followed his interpretation of the QAS CPM for asthma. Another ethical dilemma is the question of whether Mr. Peters' motives were fueled by his self-interest or intent. Mr. Peters may have purposely interpreted the CPM consider adrenaline to align with his choice of drug to administer, promoting his own self-interest that he is right. However, adrenaline was considered using his clinical judgment, which followed the CPM through the administration of salbutamol. By analyzing Mr. Peters' actions and motives, we can argue that he acted within an ethical framework and adhered to the 4 principles of bioethics by behaving ethically, using clinical judgment, obeying his scope of practice, and trying to minimize harm.